Did you know an 18 or 19-year-old can be arrested and charged with child pornography for sending and receiving nudes from a 16 or 17-year-old? Watch this video to learn more. I'm Adam Rossen, founder of the Rossen Law Firm. We're criminal defense attorneys throughout South Florida, and we specialize in sex crimes. And in this video, we're going to be talking about the ins and the outs of teenagers, adult teenagers, who are sexting with teenagers under 18, so 16 and 17-year-olds specifically, and how those older teens, 18 and 19, can be arrested for possession or distribution of child pornography. Now, in another video, we talked about both parties being minors, so a 16, 17-year-old sexting with another 16 or 17-year-old. And in this one, it's different. And really, the only thing that makes it different is now somebody's crossed this magical 18-year-old mark, and now they're considered adults versus a 17-year-old who's not. So, to me, it sounds a little ridiculous, but you folks need to understand and really know the major differences of this, because you don't want your friends, your family, your children, or yourself to be hit with a child pornography charge for consensual sexting. That's the key word, consensual. Okay. Now, when we're looking at these cases, it would be possession or distribution of child pornography, and if the prosecutors wanted to, which sometimes they do, they could charge you for each and every video or image. So if you're in a consensual relationship with somebody who's, let's say, 17, 16, 17, and maybe there's, throughout the course of the relationship, there's 30 nudes being sent, well, you know what? That's 5 years maximum in prison times 30. Okay? I'm not a math major, but I believe that's 150 years in prison. That's a lot of time. Doesn't mean you're going to get that, but I want you to understand that the prosecutors have the ability to stack these charges on top of one another. And, personally, I don't think it's right, but that's the way that the law is. So as we're evaluating these, you have to understand, what really can happen in scenarios such as this. Now, the penalties, like I said, is a third-degree felony. It's a max punishment of up to 5 years in prison for each and every image or video that they decide to prosecute you on. So quite often in these cases, a client will come to me and they'll say, well, Adam, I didn't know. I dated this girl for 3 weeks. She told me she was 19. Now I'm finding out that she was 17. How was I supposed to know, right? And if you can put yourself in that person's shoes, that is a terrible position to be in. It's terrifying. It's scary. But the problem is that many years ago, the Florida Legislature, they passed a law saying that that is inadmissible at trial. It's irrelevant. And what they have on these cases is called strict liability, meaning doesn't matter if the, in this case, they're going to say alleged victim, even though I don't believe they're really a victim, but if this other person lied about their age, if they, if they tricked you, coerced you into believing that they were adults, it doesn't matter. The Florida Legislature says, too bad. So you folks really need to understand this, of how important and critical this is. Now, if this situation happens, well, from the defense side, what do? And it doesn't mean that we just give up and that, sorry, you're screwed, right? Or you're SOL, shit out of luck. It doesn't mean that, okay? There's a lot of times that prosecutors, as we present this and get this evidence, the prosecutors will come to us more from a human perspective and say, yeah, this is, Adam, this is BS, this is wrong. And just because the legislature says this doesn't mean, we have to prosecute it in this way. They can use what's called prosecutorial discretion. Plus, there's a lot of other things that we can do, such as just getting general background on this person and going through the process in general. One thing that a lot of lawyers, they take a wrong approach sometimes of, they'll look at it from a pure academic standpoint of, well, that's not going to be admissible. Well, you still have to play the game, in my opinion. You still have to go through, right? Not just go through the motions, but fight. Fight the good fight. You have to take depositions of these people, and find out, was there a motive to lie? Did they set this person up to begin with, right? Why would this person go on maybe Tinder or Grindr or one of these apps and lie about their age? Or why would somebody just lie about their age in general? What else do they have to hide? So there's a lot of things that can be done on these cases, as far as good old-fashioned criminal defense, meaning state attorneys still have to prove it through evidence, because there's a difference between what you think happened, what you know happened, and what you can prove happened in a court of law under the rules of evidence and procedure. And that's the world we live in, right? And I talk about that all the time with our clients, meaning sometimes you got to go through the whole process and, to really hold their feet to the fire. And a lot of times the prosecutors can't deliver. They can't get something, into evidence, or witnesses, they don't show up, they have memory issues. There's tons of things in these cases where cases fall apart 3 months, 6 months, a year, or 2 years into the case. So hopefully you folks are never put in this position, because it's a terrible position to be in. But if you are, you need to have not just a criminal defense attorney, but a team of lawyers that really understand you, that have dealt with these cases before, because sex crimes are something where people have so much that they could lose: their reputation, their future, obviously their freedom, that you need the team that really handles these. And here at the Rossen Law Firm, we have, as of the shooting of this video, we have 7 attorneys. We only handle criminal defense work. We are experts in sex crimes. So if you have any questions about this stuff, please let us know. We want to help out. You can call us anytime at 754-206-6200.